If you have a green card and you travel internationally, stop what you are doing right now, because what I am about to tell you could save your immigration status. Checking your phone and seeing a notification that changes everything you thought you knew about your green card. You have been living in the United States for years. You have built a life here. Maybe you own a home. Maybe your children go to school here. Maybe you have a job you love. And then, in one single moment, you realize that a trip you planned months ago, a vacation to visit your aging parents overseas, a business trip you cannot cancel, might put everything you have worked for at risk. Your green card, your permanent residence, your American dream suddenly feels fragile in a way it never did before. This is not a hypothetical situation. This is the reality that thousands of green card holders are facing right now, in February 2026, as new immigration policies and updated travel restrictions are changing the rules of the game. And the worst part, most people have no idea these changes have happened until it is too late. Welcome to USCIS Explained, the channel where we break down complex immigration laws and policies into clear, simple, actionable information that you can actually use. I am so glad you are here today, because what we are about to cover could literally save your green card, your permanent resident status, and your ability to remain in the United States. Please watch this entire video because every single section contains information that builds on the last, and if you leave early, you might miss the one piece of information that matters most for your specific situation. So let us start from the very beginning, because before we can understand what has changed in February 2026, we need to understand the foundation of how green card travel has always worked and why it has always been more complicated than most people realize. A green card, officially known as a lawful permanent resident card or Form I-551, gives you the right to live and work permanently in the United States. That word permanently sounds reassuring, almost absolute. But here is what the immigration system has always made clear, even before the 2026 changes: permanent residence is not unconditional. It comes with responsibilities, and one of the most important of those responsibilities is demonstrating that the United States is your actual home, not just a place you visit occasionally while living your real life somewhere else. This concept is called abandonment of residence, and it has been the source of heartbreak for green card holders for decades. The idea is simple. If you leave the United States for too long, or if the evidence suggests that you never really intended to make the United States your permanent home, a border officer or an immigration judge can determine that you have abandoned your green card. And once that determination is made, your green card is gone. Historically, there was a rough guideline that most immigration attorneys and green card holders knew. If you stay outside the United States for less than 6 months, you are generally fine. If you stay for more than 6 months, but less than a year, you raise a red flag and may face additional questioning. If you stay for more than a year, you are presumed to have abandoned your residence unless you have a re-entry permit. This guideline was never a law. It was never a guarantee. It was a rough approximation based on decades of case law and administrative practice, and many green card holders treated it as if it were an absolute rule, which it never was. That misunderstanding has already cost many people their permanent resident status over the years. And now, in 2026, the rules have become even more complex, even more scrutinized, and even more consequential. So what exactly has changed in February 2026? Let us go through this carefully and thoroughly. The first and perhaps most significant change involves enhanced scrutiny at ports of entry for returning green card holders. U.S. Customs and Border Protection, commonly known as CBP, has implemented new protocols for inspecting lawful permanent residents who are returning from international travel. These protocols involve more detailed questioning about ties to the United States, the reasons for extended absences, and the nature of activities conducted abroad. What does this mean in practice? It means that returning green card holders can expect to face more questions at the border than they used to. Officers are now trained to look for specific indicators that suggest a person may have weakened their ties to the United States. These indicators include things like maintaining a primary residence abroad, having immediate family members living outside the United States, having employment abroad, filing taxes only in a foreign country or not filing U.S. taxes at all, and of course, having spent extended periods of time outside the country. If an officer determines that one or more of these factors are present, they can refer the returning green card holder to secondary inspection, where a more detailed interview takes place. In secondary inspection, officers can access a wide range of databases and records, including travel history, tax records, financial records, and more. The outcome of a secondary inspection can range from being allowed to enter without any issue to being told that you appear to have abandoned your residence, which can lead to you being asked to sign a Form I-407, which is a voluntary abandonment of your green card. Here is something critically important that many people do not know. You do not have to sign Form I-407. If an officer presents you with this form and asks you to sign it, you have the right to refuse. If you refuse, the officer cannot simply take your green card and send you away. Instead, they must either allow you to enter or place you in removal proceedings before an immigration judge. And before an immigration judge, you have the opportunity to present evidence that you have not abandoned your residence. This is not a small distinction. Many people, caught off guard in a stressful secondary inspection, have signed Form I-407 without fully understanding what they were signing, believing they had no choice. They did have a choice, and knowing that you have a choice could be the difference between keeping your green card and losing it forever. The second major change in February 2026 relates to the treatment of re-entry permits. A re-entry permit, which is obtained by filing Form I-131 before leaving the United States, has traditionally been the tool that allows green card holders to travel abroad for extended periods, typically up to 2 years, without being presumed to have abandoned their residence. The important change here is that re-entry permits are now being scrutinized more carefully, both at the time of application and at the time of use. Previously, having a valid re-entry permit was treated almost as a complete shield against abandonment findings. Now, immigration officers and consular officers are taking the position that a re-entry permit is evidence of intent, but it is not conclusive proof that residence has been maintained. What this means is that even if you have a valid re-entry permit, you can still be questioned about whether you have actually maintained your ties to the United States during your absence. If you have not, if you have lived entirely abroad, given up your U.S. residence, stopped filing U.S. taxes, and have no significant ties remaining in the country, a re-entry permit may not protect you. The practical implications of this are significant. If you are planning to travel abroad for an extended period and you intend to obtain a re-entry permit, you need to do more than just file the paperwork. You need to actively maintain your connections to the United States throughout your absence. This means keeping a U.S. address, whether that is your own home, a family member's home, or a rented property. It means filing your U.S. tax returns every year. It means keeping U.S. bank accounts active. It means returning to the United States periodically, even if you are on a 2-year permit. And it means keeping records of all of these things so that if you are ever questioned, you can demonstrate clearly and convincingly that you never intended to abandon your U.S. residence. The third change that took effect in February 2026 involves the use of advanced technology in border inspections. Customs and Border Protection has deployed new data analytics tools that analyze the travel patterns of lawful permanent residents and flag those whose patterns suggest possible abandonment of residence. In practical terms, This means that when you arrive at a U.S. port of entry, a computer system has already analyzed your travel history before you even reach the inspection booth. If that system has flagged your travel pattern as potentially concerning, the officer at the booth will be alerted, and you are more likely to be referred to secondary inspection, regardless of how confidently you present yourself or how straightforward your explanations seem. The factors that these systems analyze include the total number of days spent outside the United States in the past year and in the past 5 years, the frequency of trips abroad, the length of each individual trip, whether trips appear to follow a pattern of spending just enough time in the United States to reset a timer before leaving again, and various other data points. This is a significant development because it removes some of the human element from the initial screening. In the past, a confident, well-prepared traveler might have sailed through primary inspection without any issues simply because they presented themselves well. Now, a computer algorithm may flag you for secondary inspection before you have said a single word. The lesson here is that your travel history matters enormously, and it matters in ways that go beyond any individual trip. Every day you spend outside the United States is being tracked. Every pattern in your travel behavior is being analyzed. This is the reality of immigration enforcement in 2026, and green card holders need to plan their travel with this reality in mind. The fourth change relates to specific travel restrictions that have been implemented in connection with certain countries. Without getting into the geopolitical details, there are several countries toward which the United States government has implemented enhanced travel restrictions as of February 2026. If you are a green card holder who has traveled to or resided in one of these countries, you should be aware that your travel may receive additional scrutiny. These restrictions are separate from and in addition to the general scrutiny that all returning green card holders now face. They reflect specific national security and foreign policy concerns, and they can affect green card holders regardless of their nationality. In other words, it is not just about which country's passport you hold, it is about which countries you have visited. If you have recently traveled to any country that is currently subject to heightened U.S. travel restrictions or advisories, I strongly recommend consulting with a qualified immigration attorney before returning to the United States, particularly if you have also spent significant time outside the country, or if you have other factors that might raise questions about your ties to the United States. The fifth change in February 2026 concerns the process for obtaining a carrier documentation letter, also sometimes called a boarding foil or transportation letter. This is a document issued by a U.S. consulate or embassy that allows a lawful permanent resident to board a flight to the United States when their green card has expired or when they have been abroad for more than 1 year without a re-entry permit. Previously, obtaining this letter was a relatively straightforward consular process. The consul would conduct a brief interview, verify that the person had not abandoned their residence, and issue the letter. Now, this process is more rigorous. Consular officers are applying more stringent standards in evaluating whether a returning permanent resident has maintained their ties to the United States, and the process is taking longer, sometimes significantly longer. If you find yourself abroad with an expired green card or without a re-entry permit after more than a year, you should not assume that you can simply walk into a U.S. consulate and get a letter to board a flight home. You should prepare extensive documentation of your ties to the United States, and you should expect the process to take time. And once again, consulting with an immigration attorney before you go to the consulate can be enormously helpful. Now, having gone through the 5 major changes, let us talk about what you should actually do in response to all of this, because information without action is just anxiety. And what we want to give you here is not anxiety, but preparation. The first and most fundamental thing you can do is to take stock of your travel history honestly and carefully. Look back at the last 2 to 3 years and calculate how many days you have spent outside the United States versus inside. Be honest with yourself. If the numbers are not good, if you have been spending more time abroad than in the United States, then you need to address this proactively. Not wait until you are standing in a secondary inspection room trying to explain yourself. The second thing you should do is to review and strengthen your ties to the United States. What does your life here look like on paper? Do you have a U.S. address? Do you file U.S. taxes? Do you have a U.S. bank account? Do you have a U.S. driver's license? Do you have family members in the United States? Do you have employment or business interests here? The more of these boxes you can check, the stronger your case that you are a genuine permanent resident who intends to make the United States your home. If some of these boxes are not checked, now is the time to address that. Renew your driver's license if it has expired. Make sure your tax filings are up to date. If you have let a U.S. bank account go dormant, reactivate it. These are not just bureaucratic formalities, they are evidence of your connection to this country. The third thing you should do, if you are planning any significant international travel, is to consult with a qualified immigration attorney beforehand. I know that sounds like expensive advice, and it does cost money, but it costs far less than losing your permanent residence and having to go through the entire immigration process again, or potentially being barred from returning to the United States entirely. An immigration attorney can review your specific situation, analyze your travel history, evaluate your ties to the United States, advise you on whether a re-entry permit is appropriate for your circumstances, help you prepare documentation to bring with you when you travel, and give you advice about how to handle a potential secondary inspection if it occurs. The fourth thing to do is to keep records. Keep records of everything that demonstrates your connection to the United States. Lease agreements or mortgage statements showing your U.S. address, tax returns, bank statements, employment records, school enrollment records for your children, medical records from U.S. doctors, anything that shows that your life is rooted here. When you travel, consider carrying some of these documents with you, particularly if you are returning from a long trip. You do not need to walk into customs waving a stack of papers, but knowing that you have documentation available if you are questioned can be reassuring, and being able to produce it quickly in a secondary inspection can make a significant difference. The fifth thing is to understand your rights at the border. As a lawful permanent resident, you have rights that you should be aware of. You have the right to remain silent beyond answering basic biographical questions. You have the right to refuse to sign Form I-407. If you are placed in removal proceedings, you have the right to appear before an immigration judge. You have the right to consult with an attorney, although this right operates differently at the border than it does in a criminal context. So it is important to understand the specific rules that apply. Knowing your rights does not mean being confrontational with border officers. That is almost never a good strategy, but it means knowing what you have agreed to and what you have not agreed to, and making informed decisions in what can be a very stressful situation. Now I want to address something that I know is on the minds of many people watching this video, and that is the emotional dimension of all of this. Because we are not just talking about legal technicalities, we are talking about people's lives, families, dreams, and futures. Many green card holders travel extensively because they have real reasons to: aging parents who need care, family members who cannot easily come to the United States, business obligations that require international presence, cultural and family ties that are deep and genuine. These are not signs of disloyalty to the United States. They are simply the reality of living in an interconnected world with roots in more than one place. The frustration of feeling that your genuine permanent residence is being questioned because of circumstances that were never within your full control is real, and it is valid. And I want to acknowledge that frustration while also being honest with you. The legal system does not always account for individual circumstances with the nuance they deserve. What the system responds to is documentation, preparation, and evidence. And the more of those you have, the better your position. There is also a broader context worth acknowledging. Immigration policy in the United States has been in a state of flux and heightened enforcement for several years now. The changes taking effect in February 2026 are part of a larger trend toward more rigorous enforcement of existing laws, rather than necessarily representing entirely new legal standards. What has changed is not always the law itself, but the intensity and consistency with which it is being applied. This means that things that might have been overlooked or treated with more lenience in previous years are now being examined more carefully. And green card holders who may have been operating with a casual understanding of the rules based on how things worked in the past may find that past experience is no longer a reliable guide. I want to make sure that you leave this video not just informed, but also calm and focused. Yes, the changes are significant. Yes, they require your attention. But they are not insurmountable. Thousands of green card holders travel internationally every year and return without any problems because they have maintained genuine ties to the United States. They travel thoughtfully and they are prepared. You can be one of those people. With the right preparation, the right documentation, and the right understanding of the current rules, you can continue to travel and to live your life as a permanent resident of the United States without losing what you have worked so hard to build. Let me give you a clear and concise summary of everything we have covered today, so you have a reference point as you think about your own situation. First, Customs and Border Protection has implemented enhanced scrutiny protocols for returning green card holders, with more detailed questioning and data analysis being used to identify potential abandonment of residents. Second, re-entry permits are no longer treated as an absolute shield against abandonment findings. They must be accompanied by genuine maintenance of U.S. ties during the absence. Third, new data analytics technology is being used to analyze travel patterns before you even reach the inspection booth, meaning your entire travel history is under review. Fourth, specific travel restrictions related to certain countries have been implemented, adding an additional layer of scrutiny for green card holders who have traveled to or resided in those countries. Fifth, the process for obtaining carrier documentation letters at U.S. consulates abroad has become more rigorous and time-consuming. And in response to all of this, your action items are: review your travel history honestly, strengthen your documented ties to the United States, consult with an immigration attorney before major international travel, keep and organize records of your U.S. ties, and know your rights at the border. If you found this video helpful, and I truly hope you did, please take a moment right now to hit the like button. It takes 2 seconds, and it helps this video reach other green card holders who need this information just as much as you did. And if you are not already subscribed to USA Visa Explained, please subscribe right now and turn on the notification bell, because we cover important immigration updates like this one on a regular basis, and you do not want to miss a video that could affect your status. If you have questions about your specific situation, please leave them in the comments below. I read every single comment, and while I cannot provide personalized legal advice, I can point you in the right direction and make sure your questions inspire future videos on this channel. And most importantly, if you know someone who has a green card and travels internationally, please share this video with them today. Do not wait. Do not assume they already know this information, because the reality is most people do not know these rules have changed until they are standing in a secondary inspection room, and by then, it may be too late. Thank you so much for being here today. You took time out of your day to stay informed, and that matters. That is how you protect yourself, your family, and your future in this country. At USA Visa Explained, we are here every step of the way making sure you have the knowledge you need to navigate the American immigration system with confidence. Stay informed, stay prepared, and we will see you in the next video.